Okay, well, good afternoon, everyone. I'm Alex, and on behalf of Family Law Week, I would like to welcome you all to today's webinar hosted with RWK Goodman. Family Law Week are delighted to be joined by Kim Lehal, a partner and head of the International Children Department at RWK Goodman, and also the Family Law Week Business Development and Events Editor. Kim is joined by Jessica Lee, a barrister at 1GC Family Law, and Paige Campbell, a barrister at Harcourt Chambers. They will be presenting today's webinar on international child abduction, a guide to the 1980 Hague Convention, non-Hague cases, and Article 21 rights of access cross-border contact. But before I hand you over, just some quick housekeeping. You all are on mute, so if you have any questions, please put them in the Q&A box on your screen or the chat box, and they will go through any questions at the end of the webinar. Over to you.
Thank you, Alex. So as Alex has explained, this will be a whistle-stop tour of cross-border child abduction with Hague Convention cases and non-Hague cases. And then we will talk about Article 21 proceedings, which relate to cross-border contact. I'll just take the next slide. So here's some information about us and who we are and what we do. As Alex has said, I head up the international children team at RWK Goodman in London. Jess is a barrister who specialises in family law, in particular children proceedings at 1GC. And similarly, Paige is at Harcourt Chambers, who also specialises in all aspects of children proceedings. I will start off by talking about the 1980 Hague Convention. So when we think about the 1980 Hague Convention, it's a convention which is basically a treaty that seeks to protect children from the harmful effects of abduction and retention across international borders. And essentially, the overarching objective is for countries to determine which country is going to make the long-term decisions about a child's welfare in terms of what we would ordinarily refer to as child arrangement proceedings and contact proceedings. So where children, for example, move across a border from another country to this country, our courts will be deciding whether the children are going to remain here, and it will be the English court that will exercise its jurisdiction over the children, or whether the children will be returned to the other country, and it will be that country that determines those matters. Article 12 of the Convention is pivotal as it mandates the immediate return of any children who have been wrongfully removed or wrongfully retained in any contracting state to their country of habitual residence. There are 78 contracting states with England, and other countries will have entered into the 1980 Hague Convention with other countries that we may not have signed up with. Predominantly, we are signatory with Western world countries, Europe, New Zealand, Australia, the US, and the HCCH website has a list of all of the countries that we are signatory to. And there is a link, I believe, at the end of these slides for you to have a look at those countries in your own time. So I'm going to start by talking about the distinction between incoming and outgoing cases. So an outgoing case is where a child is removed to another country, and the litigation will happen there. It will not happen here. An incoming case is where a child is brought into England and Wales, and the litigation will happen here in the High Court. In terms of establishing a case, so we're just focusing on incoming cases. So we would be representing the left behind parent in the foreign country. So for them to establish a case of international child abduction, the parent that's left behind would have to first establish that they have rights of custody. And by rights of custody, we mean the equivalent of parental responsibility. And they must have been exercising those rights of custody at the time that the child left the country. Secondly, the left behind parent has to establish that the child was habitually resident in the country they are seeking the return to. So it needs to be where the child was integrated into their social and their home environment, and that they had been there for a significant period of time, and basically that's where their life was. Thirdly, there has to have been a wrongful removal or a wrongful retention. And the difference between those is that a wrongful removal happens where a child is removed in a clandestine fashion without the other parent's consent or knowledge. And a wrongful retention happens where, for example, a child leaves the country for an agreed period of time, for example, for a holiday, and then the child is not returned after that period. And then finally, the application for a return to the home country must have been made within 12 months. So once an applicant has established all of those factors with evidence, they make their application to the central authority in England and Wales through the central authority in their country. So say, for example, a child had been removed from Spain to England. The left behind parent would make their application to the central authority in Spain. They would fill out an application form with their evidence proving these matters, and then that application would be sent to the central authority in England and Wales, who would then assess that application and then appoint a solicitor who is on the approved panel, specialising in international child abduction proceedings under the 1980 Hague Convention. And then that solicitor would prepare the application. And when we receive these applications, one of the first things that we need to consider is the respondent, so is the parent who has removed the child, could they be an onward flight risk? Should proceedings be issued without notice or on notice? If we're going without notice, ordinarily we would look to consider seeking a passport order, which would instruct the tip staff to remove passports and put port alert in place. And if in circumstances the respondent's whereabouts are unknown, so they've come to England and the left behind parent has no idea where they could be in England, then consideration would be given to whether disclosure orders and a location order is needed, which essentially does the same thing. A disclosure order would be against various offices like the Department for Work and Pensions, HMRC, mobile phone companies, the Department of Education, the NHS. And once an address is found, it will be provided to the tip staff, and they would execute the location order, which would basically do the same thing as a passport order to remove passports, and those passports would be held at the High Court at the tip, but by the tip staff until the end of the proceedings. So once the respondent has been found and we enter into the proceedings, the respondent is then required to file and serve an answer setting out exactly what defences, if any, they seek to rely upon. And usually that request that is directed by the court at the first ex parte hearing, so that by the time we get to the first hearing, everyone has an indication of what defences, if any, the respondent is seeking to run, so that appropriate directions can be made to timetable at that first hearing. In terms of defences, there are only 5 that a respondent can rely upon, so they're quite narrow. And what I will do is I will go through each one in turn. So the first one, well, actually, the first point to make is that these proceedings are summary in nature. And by summary, what I mean is that it's very rare that any party will give evidence in the proceedings. So everything must go into the statement, and the statement usually contains far more detail than you would see in any other proceedings. Because that is all that a judge is going to consider, unless an expert is appointed, or there's an issue over consent, which I'll talk about when I go through each defence. So it's really important that as much detail goes into the statement, but equally it's quite high pressured because these proceedings ordinarily are dealt with within 6 weeks. So it means gathering a lot of evidence, usually from the home country, which can pose a number of challenges, to get all of the evidence together and as strong as possible. So looking at this from a respondent's perspective, the first defence that they can seek to rely upon is that the left behind parent consented to the removal, or they subsequently acquiesced by virtue of their actions. So consent takes place before the removal, and acquiescence takes place after the removal. Any consent must be real, informed, positive, and unequivocal. And where there is a consent defence being run, it is a fact-specific inquiry. And this is why the evidence is so important. In relation to acquiescence, the court will look at the words or actions of the left behind parent. For example, have they travelled to England to see the children and spent a significant period of time in England? A careful analysis will need to be taken of messages exchanged between the parties, emails. Ideally, any consent would be in written format, because anything else will be implied, which is very difficult to prove. And this is probably the only defence where a judge may want to hear oral evidence from the parties to assess credibility. The second defence is rights of custody. Now, this defence is only usually applicable in the most exceptional circumstances. For example, where a left behind parent has abandoned a child, or allowed a child to be looked after by others, or, for example, they don't have the equivalent of parental responsibility in the left behind country. They're not named on the birth certificate, for example. But the other important thing to remember about rights of custody is that that parent must have been exercising them at the time of the removal. And I would say, I think rights of custody, I mean, they're quite rare. I don't think I've ever done one, because they are so exceptional. The third defence, and this is the one that we see frequently, I would say, in every case pretty much, is that there is a grave risk that the child's return would cause both physical or psychological harm, or otherwise place them in an intolerable situation. And the key point here is that it's the harm and the intolerability to the child. And what we see in these defences that are run, that predominantly domestic abuse is pleaded. And it's really important that when preparing evidence that there is a detailed chronology with dates and times of instance, especially where the child has been present, because the key here is to ensure that it relates to the harm that would be caused to the child. So usually it would be a primary carer who will say that if they were returned, they would be sent back to a situation where they would be subjected to very serious domestic abuse. And that would have an impact on the child, who has 9 times out of 10 witnessed the abuse. Other things to think about here are impact on mental health. Quite often we see cases where a return would cause a deterioration in mental health, and that in turn would create an intolerable situation if it's having an impact on the primary carer's ability to then care for the child on a day-to-day basis. And here we would see potentially a psychiatric or a psychological evaluation. The other things to look for here are financial destitution. Would a respondent be potentially being sent back to a situation where they would be homeless and destitute? The other issues to consider are immigration position. Does a parent who's removed a child have a permanent immigration position if they were to be returned? Were they relying on the other parent? Is their visa still continuing? Has it been, has the left behind parent done anything to have an impact on their visa position? And there again is where we may see expert evidence from an immigration expert to advise on that. Other points to consider are the length of time a relocation application would take in the left behind country. Some jurisdictions don't have domestic abuse laws in their country, and some countries do not have a relocation jurisdiction. So it's really important that that is considered. And I'll talk a bit more when I go on to explain protective measures, about the importance of considering expert evidence from foreign lawyers in the left behind country to understand how the domestic law operates and what protections that can provide if a respondent is being returned with children. So that then takes me nicely onto protective measures. So the court will take any any allegations under Article 13B, which is the grave risk of harm and intolerable situation defence. So the English court will take those allegations at their highest, and will then consider if there are any protective measures which can ameliorate that risk temporarily. So any protective measures are designed to be temporary, short term, usually for 3 to 6 months, or until the parties can go before the domestic court, where a judge can evaluate everything properly at that point. And I would say that in the English court at the moment, this is where we're seeing the most amount of scrutiny by the court in terms of considering whether any protective measures that can be put in place are actually fit for purpose. So just taking some examples of what a protective measure could look like. It could be, for example, the left behind parent may have made a report to the police, because human instinct, first of all, your children go missing, is to contact the police, to report it to the police. So the first protective measure we would expect to see from an applicant is that they will not support or initiate criminal prosecution or any other civil proceedings against the respondent relating to the abduction if a return order is made. Other protective measures could be, on the basis of no admissions, that the applicant will not intimidate, harass or pester the respondent, similar to a non-molestation order in this country, not to remove the children from the respondent's care, not to attend at the airport on the day of arrival, to meet the reasonable travel costs of the respondent and the children, not to attend, not to attend at the airport, to vacate the former matrimonial home. And this one's always a sticking point, because a person who's been a victim of domestic abuse is not going to want to go and live in the former matrimonial home with the applicant, and may not have a support network or anywhere else to live. So this one's quite important in terms of providing accommodation. And if it's not letting them back into the matrimonial home, then it's consideration as to whether a suitable property can be rented. The next one is maintenance. Again, goes back to the financial destitution point, is quite often someone may be going back to unemployment initially. So the consideration of maintenance is also quite important. I've skipped ahead slightly. The next offence is child objections. Now, this kicks in if the child is of an age and maturity of which it is appropriate to take account of the child's views. It must be an objection from the child to the country, and not returning to the left behind parent, and that's quite important. This is where we would see CAFCAS become involved, usually where a child is around the age of 8 onwards. And the CAFCAS High Court team would be directed to prepare a wishes and feelings report and consider whether the children should be separately represented. And then the final defence is that the children are now settled within the UK. And that's usually where they have been here for more than 12 months, which is why it's extremely important that an applicant issues those proceedings before the 12 months are up. So that is a summary of the 1980 Hague Convention, how it operates from an applicant's perspective and a respondent's perspective. The other important thing to note is the legal aid position and the distinction between incoming and outgoing cases. So an applicant will always be entitled to non-means and non-merits tested legal aid. So regardless of their income, their assets, they are entitled to legal aid. And ICACU will issue a funding letter to the law firm that's instructed from the panel, and the legal aid application is granted almost instantly. Whereas a respondent is not entitled to legal aid as of right. There is a campaign about changing that, but as it stands at the moment, any legal aid for a respondent is means and merits tested, but they don't have to comply with LASVO evidence. So they do not need to have evidence that they are a victim of domestic abuse. They simply have to show means and merits in an ordinary way in terms of the merits of their case. There is no legal aid available for outgoing cases. So an outgoing abduction would be an applicant here in this country whose child has been removed to a foreign country. They would complete their ICACU form, and they would send that to the central authority in England and Wales, who would then send it to the other country, and then that country would appoint a solicitor there for them. Legal aid is not always available in other countries. Quite often the Department of State will run the case, but it's not always available in the same way it is here. So that is a summary of the 1980 Hague Convention. I'm now going to pass over to Jess, who's going to walk us through what the position is in relation to non-Hague cases and cases that come before the High Court under the inherent jurisdiction.
Thanks, Kim. Thank you very much. And we'll start with, so we're now moving over to non-Hague, as Kim has just told us, inherent jurisdiction cases. And I suppose the headline point, just to have in your mind, is that as Kim has taken us through those 5 defences, it's well structured. There's quite a clear format to those applications. When it comes to non-Hague, you've got to absolutely have at the centre welfare considerations and sort of pulling together evidence in a similar way, but you need to know that the structure for those applications is different. And I'll just go through and explain what I mean by that. I'm going to talk a little bit about the sort of landmark case on that, and that's certainly something that's useful to always have in your mind. So we're going to start about if a child has been abducted into this jurisdiction for a country that's not a signatory. Okay, and similarly to as Kim explained for Hague cases, time is often of the essence. You do need to get your High Court application in. We've got the form number for you there. So no time to waste. You do need to act promptly and get that matter before the High Court judge as soon as you possibly can. We've set out there the relevant practice directions for you to look at. I'm sure you'll know Part 12, Chapter 5, that's about inherent jurisdiction, and you've got the supplementary Part 12D, and then Part 12F, you've got international child abduction, including the non-Hague Convention. It's always useful to have those practice directions up your sleeve, as it were, when you're making these applications, really from the start when you're filling in that form. So just having a look at the legal principles, the leading authority you'll see there in the box, RWK, back in 2006. So this is when the House of Lords, and the leading judgment was given by Baroness Hale. And what the basic facts of that case, just to put a little bit of meat on that bone, is that it concerned a boy who had been born in the USA in 2000. And for medical reasons, shortly after that time, he went to the Kingdom of Saudi Arabia. He was a citizen of also not just the States, but Saudi Arabia and the UK, because the mother was born in the UK. Her parents had come to this jurisdiction as refugees, but she also went to Saudi Arabia when she was 6, so had dual citizenship. The mother, in a nutshell, the mother returns to the UK for her A-levels in university, and then she goes back to Saudi where she meets her husband, and they have the little boy. The father is a Saudi citizen. The couple, there is some history. They divorce, they get remarried. It's a situation that does change a little for a couple of years. But the upshot is, after they finally separate, the father applies. In fact, it was back in 2003 for a specific issue order for a summary return to Saudi of the child. The father saying always that the child was to live with the mother effectively, but wanted the childhood to take place in Saudi. And I suppose the reason I'm giving a little bit of the facts on this is just sort of anecdotally, but in my experience, we've had an increase of cases involving Saudi Arabia. It's well known. We can all read about the opening up of business in Saudi, the increased number of flights, and so on. There's quite an effort by the Saudi by Saudi at the minute to encourage movement business, and of course what goes with that is human relationships and so on. And I think there is a knock-on from that. So just it's really coincidental, but the leading case in this matter very much was based with a Saudi angle. So that's just something to bear in mind. And in terms of then one other aspect, I would also just say now to bear in mind is asylum status. I'm going to tell you a little bit more about the outcome of RWK, but the reason I just want to add in now about asylum, ask the questions early on. The leading case on asylum is RWK, and again, you've got the citation there. That was about an 8-year-old girl. She was born in South Africa. She had been habitually resident her whole life here. Her mother wrongly removed the child to England, and the father applied for under 1980 Hague. So the point with it was that the mother had made an application for asylum, and she had named the little girl, her daughter, on the asylum application, and that application was pending. And what was held is that the grant of asylum or refugee status to a child is an absolute bar to the implementation of any order directing the child's return to another country. And what happened was that, I mean, the High Court can still determine a return application, but it's the implementation of any order. It has to be stayed whilst the refugee and asylum claim matter is pending. So again, we've potentially got changes coming through in terms of rules around refugee status, asylum claims. So it's really something to keep a real close eye on, and also just check when anything's gone through Parliament, when it's enacted, when it goes on the statute books. It's going to be really important, I think, in the next year or two to keep a close eye on that, because it might have an impact on some of our cases. So have that in mind. And in terms of the principles of RWK, a number of principles were laid out that really stand right today. The child's welfare is the court's paramount consideration. It's, of course, a thread we know runs throughout really any application with respect to the child in this jurisdiction. But it is a plank, again, for non-Hague cases. The principles of the Hague Convention should not be extended to non-Hague Convention countries. So where Kim took you through those 5 defences in particular and the approach to be taken, whilst those points you might want to have them in your mind, you've really got to be careful not to run the case in a mirror way. It is not a Hague Convention case. The considerations are they ebb and flow a little more. It's not as structured. So you need to think about that. And and judges need to be reminded or it perhaps politely pointed out to them at times, not to sort of veer into that structured defence approach. Okay. The court does have the power, in accordance with the welfare principle, to order the immediate return of a child to a foreign jurisdiction without conducting a full investigation of the merits. So these cases can move very quickly. There's no obligation on the High Court judge to undertake that. Yes, it's the welfare considerations, but it is not a lengthy, months and months long exercise. And whilst discouragement is, of course, given for kidnapping, it needs to be looked at in the form of a swift, practical and welfare-focused assessment of the child's best interests. And it may, in appropriate cases, justify prompt return of a child to their own country. So it's never at the expense of the child's welfare, but you need to have in your mind that in terms of decisions High Court judges taking, that is their approach. And a summary return, it's not the automatic response to every unauthorised removal, but it's certainly, in my experience, it often does align with the child's best interests, because they're not embarking, as I say, on that extensive, lengthy forensic look into child's background, merits, etc. It's a different approach. So it is the individual child and the circumstances. And whilst, of course, you always go to the body of case law that's available, you need to be ready to highlight points for that individual child where necessary. And then you'll see in the purple boxes on the screen there, box toward the bottom, those the factors, so the paragraphs you need really of the judgment are 33 to 41. And it's those points: the degree of connection, the length of time that a child has spent in each country, the degree to which courts of the country of origin apply similar welfare concepts to this jurisdiction. So you need to bear that in mind and address the judge suitably. And then the effects of this decision on the primary carer. So I'm going to contrast that to Kim's point about Defence 13B and how I agree with Kim. We often have domestic abuse pleaded. It's important to get that evidence together. It can be, of course, you would raise it, but it's the effect on the primary carer in a more sort of global, maybe a slightly stand back approach rather than a direct defence. So that goes to the sort of differences. I'm going to move now on to return to a non-Hague country. So the child is brought to England and Wales, but where a child's been abducted from this jurisdiction, the court may be able to make orders. But you'll see from the box there, when a child has gone to a country that's a non-signatory, what are your options here? Well, you'll see you've got inherent jurisdiction again, of course, habitual residence here, very important, and enforcement. Also, you need to know the principles are very important. Re J, they apply. We've included there for another important case, NG and GA. You need to take that into account as well. I've put the Foreign and Commonwealth Development Office there because it's very difficult when it's a child has gone to a non-signatory country. It's even more of a challenge, I think, I would say, in terms of managing a client, looking after them, managing their expectations. It can be quite a challenging situation. You will be reliant on experience with other cases. Obviously, you've got some case law, but I would always go back to the Foreign and Commonwealth website. In practice, there is actually quite a wealth of information available through the Foreign Office about individual countries. That is what they do. So you need to look very much at practicalities. How often are flights? What travel documents would anybody need to get out there? And so on. I mean, it's the full remit really of practicalities. There is some financial assistance available through the Foreign Commerce Development Office. It's on a case-by-case basis, and it may not be available. But I would say for an early start, try and find out those practical arrangements and what is possible in terms of travel to that country just as soon as you can. I've highlighted a couple of countries because you also need to always check if there are, even if it's a sort of headline, it's a non-Hague country, we'll find that there might be additional, either a convention or some sort of agreement between England and Wales and another country, and you need to know about that. So it won't move it into a Hague Convention country potentially, but it might give you some more sort of tools in the toolbox in able to argue your case. So I've highlighted Pakistan there. It did ratify the 1980 Hague Convention in 2016, and that did enter into force. But the convention does not operate bilaterally. So therefore, a bilateral agreement remains in place to deal with child abduction cases. Now, there was an update on this in January 2003. The then president of the Family Division and the Honourable Chief Justice of Pakistan, they reached a consensus on how child abduction cases concerning the two countries are to be dealt with. and it's called the Anglo-Pakistan Protocol. The protocol recognises that the courts of the child's habitual residence are best placed to decide welfare issues, and it provides for cases to be dealt with swiftly and cooperatively by both jurisdictions. So that is certainly a protocol that you would need to look up, and you'd want to look up if your case does concern Pakistan. Equally, just giving another example here for Egypt, so it's not a contracting state, it's a 1980 Hague, but in January 2005, senior judges from the UK and Egypt, they signed a declaration, and it affirmed the principles of the UN Convention of Rights for Child, 1989, including that child's welfare is paramount and that contact with both parents should be maintained. So again, it doesn't move you into being a contracting state, but it's a very useful document and declaration to be aware of and to bring to the attention of a judge. So again, really have in mind, do research when a country comes up which maybe you're not familiar with, that you haven't had a case on before. Make those inquiries. Has there been any additional protocol signed? Also have a look if anything is imminent. Always make sure you check the state of play with that other country. Something may be just coming down the track. Now, again, speed is of the essence, so it might not be that helpful, but you just need to know what the options are. In terms of legal aid, I will say from the outset, I do feel that solicitors rather than counsel always better to advise on legal aid, but the headline point you need to know is that there is no automatic entitlement for non-Hague cases. Applicants and respondents, they can apply for the means and merits tested legal aid, but again, it's not subject to the LASPO requirements. You can get emergency funding though under the delegated functions for urgent cases. And again, absolutely worth, because speed is often of an element of these cases and urgency. That is an application you need to be ready, but clients need to be told about the no automatic entitlement from the outset. So that's a whistle-stop tour really through return to non-Hague countries and inherent jurisdiction. And I think it perhaps highlights the real need to keep a broader view, not just on the case law that's coming through, but it really is the state of play internationally, any forthcoming protocols, and any type of reciprocal arrangements which may be there. And you do need to look on a country-by-country basis to see where there is. Also, I think the non-Hague countries that I mentioned, Saudi Arabia, it's just one, but there's other countries where we're having increasing agreements on, trade or business and so on and so on. Things that may be moving quite quickly in that regard. So always keep an eye on anything that's coming along that may change how you want to put your case for your client. Thanks very much.
Great, thank you, Jess. Now it's over to me to talk to you a bit more about cross-border contact, and in particular Article 21. So what is Article 21 of the Hague Convention? Well, the headline is that it's essentially a gateway mechanism to bringing international access disputes to court. And the exact wording set out in Article 21 is on the slide in front of you now. I won't read it out. The main points are essentially that it specifically deals with protection of rights of access, and in particular, I highlight the section that says that it provides a mechanism for a parent living abroad to issue an application for arrangements for organising or securing the effective exercise of rights of access. Now, what's quite interesting about Article 21 is that across the signatories, there is a different interpretation of how they apply Article 21 in their respective countries. In general, there are two ways in which the provision's usually interpreted. The first is what might be called a narrow or more limited approach, which is that Article 21 does not provide any independent source of jurisdiction. And this is essentially the approach that we see in the courts in this country, in England and Wales. But there is a wider view and a wider interpretation of this article, and that is that it does confer a separate jurisdiction, and that's a view that's taken in a number of countries across the world, for example, Israel. So there is a real difference across the member states. There's a lack of uniformity that can, in and of itself, raise questions, and there's quite a bit of debate about it. And there's also a difference in respect of implementation and enforcement across signatory states, because arguably the Article 21 does not in and of itself set out procedures to implementing access orders, and many contracting states failed to ensure enforcement. So just from the outset, I think that's quite interesting to bear in mind that actually we have this article, but it is being interpreted differently across different member states. Now, turning back to England, because of course that's what I'm sure you're all most interested in, it's quite clear, and it has been established in this country, that we are following the narrow interpretation of Article 21. There's a case called Regia Minor, 1993 1 FLR 669, that sets that out in particular. There's no jurisdiction that's conferred as a result of this article, and that any application essentially must be dealt with under the Children Act 1989, so domestic law. And it won't be a surprise to you that, of course, the paramount consideration then when considering applications under the Children Act is the welfare of the child. And so that's really what's going to be at the forefront of any applications for international contact. What the case I've just referred to also sets out is that essentially if there's already a foreign order in place, then the court is considered entitled to give grave consideration to it. But ultimately, even in those circumstances, the welfare of the child prevails. So we're very firmly sticking with the principles that we've got established in domestic law under the Children Act 1989. Now, Article 21, I've already referred to it, sets out quite a bit about rights of access. So I'll tell you a bit more about it. Rights of access is essentially set out and dealt with in Articles 5 and Articles 21 of the 1980 Hague Convention. Article 5 essentially states that rights of access shall include the right to take a child for a limited period of time to a place other than the child's habitual residence. And Article 21, as I was touching upon earlier, essentially focuses on making arrangements for organising and securing the effective exercise of rights of access. Now, rights of access can actually be interpreted quite widely, and we have the case of ANC that's on the slide, so hopefully you can see the citation there. And why I highlight this case is because Mr. Justice Cohen in that case considered that rights of access must be understood as referring not only to the rights of access of parents to their child, but also to the rights of access of other persons with whom it is important for the child to maintain a personal relationship, among others, that child's grandparents, whether or not they are holders of parental responsibility. Now, that's really important to bear in mind because it essentially means that applicants can include members of the family, such as grandmothers and aunts. So it's important to bear in mind that it's not just parents who can be applicants in these sorts of applications. Okay, so how do we approach cross-border cases? Well, the process essentially is that initial contact is made with the central authority. And the central authority is essentially, in this context, responsible to take steps to prevent any obstacles to rights of access. They are required to essentially take all appropriate measures to initiate and facilitate the start of judicial proceedings, either directly or through an intermediary. So your first step is, as an applicant, is to contact the central authority. They will then allocate to a specialist solicitor who will make the application. Now, as I said earlier, the application is made under the Children Act, so it will be a C100 application with a supporting statement. So very much at that stage, you start following the usual trajectory that you would for a Children Act application. Just in terms of the funding position for an applicant, it's important to bear in mind that an applicant has automatic legal aid, which is quite interesting and arguably problematic because other applicants in Children Act proceedings do not have automatic legal aid. So whilst it's helpful in these proceedings, there is a disparity when we think about applicants in Children Act applications that don't have this international nature. So it's important to bear that in mind. And why I'm flagging this legal aid position is because I certainly have in practice seen quite often, and I'm sure that sentiment's held across the panel, that there have been a number of cases where an applicant has either been privately funding their application, or has been acting as a litigant in person because they don't recognise and realise that they are actually automatically entitled to legal aid. So it is a problem, one that I do think it's important that we bear in mind, because I've certainly been encountering that quite a bit. So it's important to bear it in mind. The other thing to consider is that I've had it on a few occasions where an applicant will commence proceedings just wanting contact, and during the course of those proceedings say, well, actually, I want the child to now come and live with me or to relocate. So that actually changes the nature of their application, and accordingly, that will impact upon their public funding certificate. So you've got to remain live to those sorts of issues. And again, something that I've seen crop up a few times. Now, a respondent to these sorts of applications are assessed on the standard means and merits test. So that is their position legal aid wise in these sorts of cases. So what happens after you secure funding for your applicant, if that's your client? Well, I think firstly, you need to take a very detailed account of the background from the client. So you want to be asking questions surrounding the circumstances around the child's move to this jurisdiction. Was it by agreement? And if it wasn't, when did it happen and what were the circumstances? Because you may find yourself dealing with a completely different application along the lines that Kim and Jess have already talked about. So you need to find out a bit more about the background and also about the level of contact that has been taking place both before the child moving to this country and since. And that's important to help build a picture and to also think about how to suggest a child-focused and stepped progression to contact moving forward. You, of course, want to take instructions on if there are any safeguarding issues, and you also want to go into quite a bit of detail with your client as to what they're actually prepared to do in terms of contact. Because, of course, when you've got one parent abroad, there are lots of practicalities that flow from that in terms of travel, cost, the age of the child and whether or not it'd be appropriate for them to travel independently, the frequency of any contact, their accommodation, if it's appropriate for the child to stay in or not, if the child has previously stayed in that accommodation. So you want to try and get as much information as possible. And there are other issues such as, which come perhaps even before that, for example, if the applicant even knows where the child is? Are we in a situation where we want to be thinking about asking the court for disclosure orders from the outset to even find out where the child is? So there's lots of different things you want to find out at the beginning of these proceedings to get as much information as possible. And once it's issued and before the court, it will generate at some stage, if not immediately, a safeguarding letter, as we would see in ordinary Children Act proceedings, and we'll likely see international police checks being conducted as well. Now, in terms of the progression of contact during the course of proceedings, there's often a view across courts and professionals that contact ought to commence and build up in England first, prior to taking place abroad. And that can often be really quite frustrating for applicants and for clients. So it's important that you have those very careful conversations with them quite early on, and in my view, manage their expectations, that it's highly unlikely the child will be travelling over to the country the following week or two, which sometimes is often a request. So I think it's important to manage their expectations on that. You'll often see that there's a welfare report of some sort during the course of the proceedings, and those can really vary, in my view, in quality across the country. There have been times where I've seen some CAFCAS reports and they read as if they haven't dealt with an international contact application previously. And in other cases, it's far more... they're far more used to it, as is apparent from their report. So you want to think about the different welfare reports you can get and discuss the different options with the client, and manage their expectations on that. And as I say, with any statement that you're preparing, that's where all of that really helpful information you took from the client needs to be set out. There needs to be a very clear plan, and thinking about the practicalities, thinking about financing any travel, who's going to be accompanying the child, if anyone, accommodation, what does it look like, how do we build up the contact, all of those practical details that we might not think about to the same extent when we're dealing with applications where families live in the same area. So those are the sort of practical points I'd suggest that you think about. Another thing that I think you have to be quite live to and to really keep reviewing during the course of the proceedings is what happens when an applicant travels over to spend time with a child and then the child's not made available. That's something that I'm seeing quite regularly as becoming a really contentious issue, because of course there's a substantial cost involved in that. There's a lot of planning that goes into it, and so those breaches of contact orders can become quite emotive and difficult issues in cases, and certainly it can be trickier when you're dealing with perhaps a parent who is not as open to contact, and then you're trying to balance that with the travel. So it's important to think about what you do when contact orders are breached. Are you asking for costs orders? Are you even able to get contact up and running despite several contact orders? I had a long-running case quite recently where there was such a high level of hostility towards contact, and repeated breaches of orders, cost orders not really being that effective. And in the end, my client changed his application to seek permission for the child to relocate. And that ended up being successful at the conclusion of those proceedings. So you really want to keep reviewing the position throughout the proceedings, and perhaps give your client some really firm instructions when things are not necessarily going to plan. So it's something to really bear in mind, and to keep under review is not just getting the contact up and running, but how we enforce it if we're dealing with some hurdles to that on the ground. So that's really just a whistle-stop tour of what Article 21 is, cross-border contact, disputes, some of the practical things to think about when navigating the process, and also just a few things to think about in the event that there are some difficulties on the ground in getting it up and running. So hopefully that helps when you next approach your next application for a cross-border contact.
Thanks, Paige. I think that takes us nicely on to any questions.
Right, no questions yet, but we'll just any questions if you wanted to put them in the Q&A box or the chat box. We've had a question, would legal aid extend to breaches of contact orders?
Well, shall I answer that? It should do. In terms of breach and enforcement of a contact order, there is legal aid available for that, but I believe it's means and merits tested. So I think if someone already has funding for, already has a legal aid certificate, it should just be a straightforward amendment to that existing legal aid certificate.
Thanks, Kim. Another question, should A21 be issued at the local family court? Previously, there was some confusion if the application should be issued at the High Court, C66 or local family court.
This is really interesting with Article 21s. I think if you need a disclosure order, it's definitely in the High Court. And I know that the guidance definitely says that it should be in the High Court, but where I haven't needed a disclosure order to save time more than anything, I've gone straight to the local court where the child is living. So, for example, if I know that the child is, I don't know, living in Manchester, I would issue in the Manchester Family Court if we knew the address. But if you don't know, it should be in the High Court. And the reason for that is if you issue in the High Court will either list it for a hearing and will be limited and not be able to do anything at that hearing and transfer the proceedings out, which builds in delay, unless you're seeking disclosure orders. Paige, have you seen the same? Jess, have you seen the same?
Yeah, absolutely. I think in circumstances where the child's whereabouts are not known and you're seeking disclosure orders, it absolutely makes sense to start in the High Court. But what we see when we are in the High Court at that first hearing after the child's whereabouts are known and once the respondent is engaging in those proceedings is a hearing where very little happens other than transferring down to the local court. And if you are able to agree something in terms of contact, you might get that as a recital on the face of the order, and directing safeguarding checks. But really, the hearing doesn't get you much further than that, because it usually comes before you have any safeguarding checks anyway. Sorry,
Yeah.
Jess.
Yeah, I'd agree with that, absolutely. I've had a very similar scenario to Paige. We weren't on the same case, but it was exactly that. And actually, once the child's whereabouts, once we had the sort of information that we needed, the High Court judge made it very clear that they didn't want to, they didn't want to step there really, and immediately transferred to the family court, to the local court. And I agree. So I would advise that if there are developments such as the child's whereabouts being confirmed and you're just going into the High Court, you need to say that straight away. Or indeed, if there's a small gap of time, you might want to let the judge's clerk know. They might just want to deal with directions on paper and not even have the hearing potentially. But that is exactly what happens. It goes straight back. Yeah, thank you.
Okay, so the next question we have is a CAFCAS report order in High Court cases?
I didn't hear that properly, Alex.
Could you say that
No.
again?
Sorry,
Thanks.
just others. Is a CAFCAS report ordered in High Court cases? Sorry.
Is one ordered? Is that the question?
Yes.
Yeah. So it depends on the type of proceedings. So, like I said, in the Hague Convention proceedings, it's only if an objections defence is being run. But
Sorry, Kim. Sorry, it's in Hague Convention cases, not High Court.
Okay, all right. In Hague cases, you would only ever see one if an objections defence was being run. So where you have a child that was around the age of 8 plus, or older children who needed separate representation, you would have the High Court, and it would be the High Court CAFCAS team who would be directed to see the child and prepare the report for the court.
Okay, thanks. We have one more question. Someone who says, "Hello, I'm an aspiring barrister, so do not have a specific question on procedure. Sorry, I was just wondering how common cases like these are in practice."
I get asked that all the time, actually, and it's really difficult to answer because this is my world in terms of my legal world. So I see it all the time, and I can see Paige and Jess nodding because this is their world too. So I would like to think there's not a lot of it, but equally we are becoming very transient. The world is becoming smaller. I don't know the statistics off the top of my head. So I would say in the grand scheme of things, there is not a lot of it, but we see a lot of it because of the field that we all work in.
Yeah. Yeah, I would add to that as well. I think although it's unlikely to be your bread and butter work once you start your pupillage and as a junior tenant, if it's an area that interests you, then I would make sure that you've got some expertise, get to some lectures and learn about it, and try and get some cases on it as soon as you can, because for all of us, it's an absolutely absorbing and quite fascinating area. I think we've all set out in our different talks, how often fast-moving events can be, why that's really relevant, and that's an aspect to it. So you're unlikely to get it in pupillage very much, and certainly maybe as a junior tenant, but I would take an interest and then explore it as soon as you can.
Thank you. I think that is all the questions we have. Yeah, there's no more questions that have come through. Well, thank you for that very excellent webinar, and thank you all for attending today's webinar. Tomorrow you will all receive a follow-up email with instructions to access the recording and slides. The next Family Law Week webinar will be taking place tomorrow. We will be hosting the final monthly training webinar of the year with His Honour Stephen Wildblood KC, who will be presenting a financial remedies update. Thank you for joining us today, and we look forward to seeing you again soon. And thank you.